Welcome, welcome, welcome. I'm having some Wi-Fi issues today, so I'm so sick and tired of Spectrum, honestly, having Wi-Fi issues. But if you guys can see me, give me a thumbs up. Let me know if you can hear and see me on Instagram. I should be fine on YouTube and Facebook because I'm hardwired. Good morning, Safar. This is your first time tuning in. Definitely comment so I can say hello. Let me know where you're tuning in from. Rare West says, good morning, best lawyer ever. God bless you. Thank you so much. Ali Olajua, good morning. Irene Jenkins, hello. Good morning. Carl on YouTube, good morning. How are you? Danny, good morning. Amanda, good morning. Rodney, Vivs. Okay, you guys can hear me good. So that's good. Let me put in my phone number here for those of you who would like to schedule a consultation. And I'm also going to put the WhatsApp. So just give me a second as I type. As you know, I can't text and type at the same time. Imachuku from Philly, good morning. 8751. Okay, I think I have all the numbers in there. Rodney at CK says, each time I come for Art Basel Miami, I think to invite you. I'm not in Florida anymore, but you know, when you mention Art Basel, it actually makes me get very emotional. As most of you know, I lost my brother 4 months ago, and my brother was an artist and actually a very, very talented shoe designer, and he was always at Art Basel. So that actually makes me a little emotional thinking about that. But I'm in Georgia, you know, someone is asking where you're located. I'm in Georgia, Atlanta, Georgia. Again, if this is your first time tuning in, my name is Aisha Chidole. I'm an immigration lawyer. I handle immigration all over the United States. You know, we handle family-based immigration, which would include like marriage-based, if you're filing for your parents, if you're filing for your children, consular processing, fiance-based immigration. We'll also handle 2-year green cards, removal of conditions to get your 10-year green card. We handle VAWA cases, T visa cases, T's for trafficking. If you've been a victim of labor trafficking, you know, where you're with an employer who has threatened you or forced you under coercion to stay there based on your immigration status or induced you for a job and where you feel trapped and they're violating labor laws, that would be trafficking. And then for U visas, if you're a victim of a serious crime and law enforcement is willing to sign a certification saying that you're cooperating with law enforcement, you can be eligible for a U visa. U visas and T visas, you know, are visas that allow you to stay here for a certain window of time, 3-4 years before you're eligible for adjustment of status for a green card. But those give you authorization to be in the United States. You know, with the VAWA case, you can file simultaneously. Typically, with the VAWA case, you can file for your green card simultaneously because that's usually attached to a U.S. citizen, like if you're a victim of abuse of a U.S. citizen or of a green card holder. Well, and, you know, obviously they have to be a spouse, you know, child or parent. So we handle those, and we handle removal cases and some detention work, depending on the location. Joan Stewart, thank you. I appreciate it. Thank you, guys. Thanks. Okay. Let's see what else. I got my first approval, a letter from my wife. So how long does it take to get the next section to begin? Without knowing what kind of approval you got, I mean, I can't really answer the question because I literally don't know what you're referring to. Like, what did you file? What is your own status? Where's your wife? You know, you guys always have a lot of questions, but I'm noticing that a lot of the questions that you guys ask, they're never complete. So it's really hard to give like a proper answer. We've actually just started something where I'm never able to answer all the questions. So going forward, like whenever I'm on live and you want to specifically talk to me about your own specific situation, comment yes, YES, on any of my lives, and we will reach out to you to get more information about whatever is going on with you. This prompt only works on Instagram. We're working on it for those of you that are on YouTube and Facebook. Hopefully it'll be there next week. But if you comment yes on my Instagram, after the live, then we can reach out to you or see what's going on with you. And hopefully we'll be able to help you specifically once we have better information on whatever it is that you're asking for. Okay, someone on Facebook is asking, how much is consultation? Our consultation fees are $150. Carl says, who's eligible for added stamp delivery mail process? There's no rhyme or reason. You can either go in there or they could tell you they'll mail it to you. There's no eligibility for either or. Frank Lucas says, I received a letter that says C31. Does it mean I have to get a different letter that says approved, or is it the same thing? Because I've been waiting like 7 weeks and I still haven't heard anything further about my case. So again, this is a vague, thank God I understand what C31 is. This is a vague question that it can be sometimes really difficult if you guys don't ask the questions properly, which is why we now have this prompt where if you can type in yes, we'll hopefully be able to help you. But in your case, I'm thinking you're referring to VAWA. I'm just making a guess that you had a VAWA case that you filed that was approved. If you have a VAWA case that you filed that was approved, you're going to get two things. You're going to get a C31 letter that's attached to a work permit and your VAWA approval. So you're going to get something that's a VAWA approval, which the VAWA approval typically comes maybe like a couple of weeks. Okay, you did confirm, yes, that it is VAWA. Your VAWA approval letter will typically come a few weeks after you get your EAD for the C31, because C31 means your VAWA case is approved. So you get that VAWA approval after you get the EAD C31 approval. Now, after that, if you file adjustment of status, what will happen is you will get scheduled for an interview or an interview bypass. I'm seeing more interviews now for the 485s for approved VAWAs. So that's what will typically happen next. And after that, if they approve you, you get a 10-year green card. So that's kind of how the process works. Okay. If a person gets a visiting visa from the previous administration and it's still valid, but he or she is from a temporary banned country, can that person still visit the US with a valid visa? Yes, and yes, you can. Remember, the rules literally, it is written there in plain English where it literally says this does not apply to those who already have obtained a valid visa before January 2026. So yes, you can still travel back and forth, as long as you have a valid visa, okay? Steven says, as a green card holder, how long before I can apply for citizenship? There are two ways in which you can apply for citizenship, either at the 3-year mark or at the 5-year mark. The answer is going to depend on how you got your green card. If you got your green card through marriage and you are still married and you're still continuously living together, this is a critical requirement, then you can file under the 3-year requirement. If you got your green card on the basis of abuse, i.e. an I-751 waiver based on abuse or VAWA based on abuse to a U.S. citizen, then you can file at the 3-year mark. If you got your green card in any other way, then it's the 5-year mark. So I hope that's clear, okay? Okay, so you said you got your green card through your son. So the answer is you have to wait 5 years. So the earliest you'll be able to put in that application is going to be 4 years and 9 months from the date on your green card. All right. My connection is so bad, guys. I can see the thing going in and out. I really need to get this Wi-Fi thing taken care of. They keep changing the date that you're going to come and install the stuff. After filing an I-751 and I get an extension, what's the next step? And can I qualify for citizenship since I've been here for 5 years without traveling out and I'm no longer with my spouse? So, okay, these are a lot of questions, Smurf, packed into one question. So let's start with the first one. When you get an I-751 filed and you get an extension, the next step is you wait until they make a decision on your case or they schedule you for an interview outside of the, biometrics. For most I-751 cases, the timeline is going to be anywhere between 2 to 3 years. Even though they give you a 48-month extension, most people are going to have a decision somewhere between the 2 to 3 year mark if you don't have an RFE or back and forth about something else. Now, the second thing you said is that do you qualify for citizenship because you've been here for 5 years? Citizenship is not determined by how long you've been in the United States. You count from how long you have had your green card and in what eligibility category. You just said also that you're no longer with your spouse. So again, first of all, the answer is going to depend on why are you no longer with your spouse? Did you file for divorce from your spouse, or did you file a 751 based on extreme cruelty or abuse? Or what exactly is the reason you're no longer with your spouse? If you're divorced from your spouse, you're going to count 5 years from the date on your green card, your original 2-year green card. If it's based on abuse and you know that you filed based on abuse, then you're going to count 3 years from the date on your original green card to determine eligibility. I mean, of course, to file for citizenship, it's not just about how long you've been here and whether you've made any international trip or not. Again, remember, guys, the N400, I always say that the application itself is the most straightforward, but it's the most difficult thing to get in terms of citizenship because that's the final step, because it is very difficult. No matter all the stuff that you're saying, it is still extremely, extremely difficult to denaturalize a person. So in order for you to file an N400, one, if you're filing based on marriage, you want to make sure that you still have a good faith marriage, right? You want to make sure that you have evidence that you and your spouse are living together. This is not one of those, okay, we're filing for a green card, they're in school here, I'm in this state or whatever. For the N400, if you want to become a citizen, there's no exception to this. You and your spouse must be living in continuous marital harmony and union in the same place for citizenship, okay? You want to make sure that you have lived wherever you're applying at minimum 3 months before you apply and continue to live there. If not, USCIS is not going to have jurisdiction. That USCIS office is not going to have jurisdiction. You want to make sure that at least half of the time of your eligibility, so if yours is based on 5 years or yours is based on 3 years, that at least half of that time you have been in the United States. So if you've traveled, you want to make sure half of that time has been in the United States. And if you've traveled for more than 6 months on one given swoop within the window of eligibility, you're teetering on the edge of breaking continuous residence. So you must prove that you're still a US resident and this trip was necessary because of X, Y, and Z, but otherwise, here are all the evidence that shows that I'm not trying to abandon my US residency. I still live in the United States. This is the reason why I had to go back, or whatever the case may be. Third thing is You want to look at your criminal history and your criminal record. Basically, for safety purposes, and I see someone ask a question about a criminal record, you want to really count from the date that your time is complete, whether that's probation, whether that's adjudication of dismissal, or whatever it is. Good moral character typically will go back 5 years. They can go back further if they want to, especially in this administration where they're doing secondary good moral character checks, but that is a safe place to be, depending on what the situation is. Now, there's certain things that I would consider like a petty offense or whatever it is. We have to, first of all, like with those, again, we have to look at them in a consultation to determine, is this enough? Or is this enough for them to deny you, where we say, you should wait, or is this fine where you should proceed? Again, an evaluation is necessary. And then the other thing is, if you are male and you got your green card between the ages of 18 and 26, and you're still under 31, or is it 32? I got to check the number again. You want to make sure that you registered for selective service, or register for selective service before you file for citizenship. For those of you who don't know what selective service is, it's like registering for the military, saying that if there's a war and they need bodies or whatever it is, you're willing to, basically represent the United States and fight for the United States. If you have a child that is under 18 that does not live with you, and this is for both women and men, you must prove financially that you support that child. You will need to provide evidence that you support that child. And then also you want to prove that you have been filing your taxes, and not only filing your taxes, but if you do owe any money in your tax return that you have not paid off, that you at least have a payment plan, that you're not just starting because you're filing for citizenship. So for instance, if you have taxes that you owe from 2024, and in 2026 you want to file for citizenship, and you're like, oh, I just set up a payment plan in 2026, they're going to say you don't have good moral character because you should have applied for it back then. In 2024, you should have applied for the payment plan then. They'll say you're only doing it. The other thing that we see a lot is multiple children by different people. Mostly, it's kind of unfair because we see them ding women more for this than men, which I think is unfair. But this is something that I've seen several times. When you have multiple children by different men, and some of them overlap while you were married, they would say you don't have good moral character. So you have to overcome that. Is it overcomable? Yes. We have clients, maybe they're even on live, that will tell you that we've overcome it for them because, there are different situations that might cause or make someone do whatever. Like, I'm not here to judge. My whole job is, what can I do in my capacity as a lawyer to get you through the hump? But these are all things that they will be looking at, outside of course, you taking the civics exam, you being able to pass the written and spoken test. That part is easy if you're a native English speaker. But these are things that you have to consider, not just time, not just how long before I can apply for citizenship. So you want to make sure all those things are good. You want to make sure that you have not committed any fraud in your original applications, because again, this is another time for them to review your case, and if they review your case and go back and say, oh, you know what, let me look at this divorce decree, especially those with divorce decree issues. This divorce decree, let's run it again. This divorce decree is not valid. They will not only deny you for your citizenship, but they can place you in removal proceedings based on your green card. So if you're applying for citizenship, you need to make sure all your ducks are in a row, okay? On YouTube, Omer says, my case has been pending with renewal prima facie only for more than 3 years now. What can I do? Sue them or send inquiries? You're not going to be very successful in the suit because you're still under a normal processing time for VAWA cases. VAWA cases are taking you go based on the processing time on USCIS. Right now they say 48 months. So you can't really sue them because you're in a normal processing window. Yeah, it sucks from a timeline perspective. Trust me, believe me, I know. I'm tired of hearing how long is it going to take, because if I could approve everybody, I would literally stamp approve, approve, approve. But we don't control that, and USCIS controls that. So you're still in a normal time. They're still doing 2022 cases right now. Okay. All right. A family member overstayed here in the U.S. 2 years for over 2 years, and they have their permanent residence interview in June back home. What can be done? Well, they can't. If they leave the country, they're certainly not coming back for the next 10 years if they don't have a 601A waiver approved. So, in order for her to go back, she needs to, first of all, get a 601A waiver approved. I'm not really sure how she got that far in the process without having a 601A waiver applied for. So that has to be done. If not, she will not be back. Okay, I think I answered this one. This is like a duplicate. I got a green card 3 years ago through VAWA, an adjustment of status. Now my lawyer says to wait for citizenship because they might ask previous marriage questions and mess with my case. That's you and your lawyer's personal case, so I can't speak. If there's nothing, if you have a genuine VAWA case and you had a genuine marriage and a genuine abuse, then you should have no problem applying for an N400. But again, that's between you and your attorney. So I don't know why your lawyer is saying that. Only you guys know, and whatever's going on with your case. I filed for VAWA. It will be 4 years in May next month, and yet nothing from the USCIS, but I'm from one of those countries that is temporarily banned. Yeah, if you're from one of those countries that's temporarily banned, well, I don't know, do you mean temporarily banned? So meaning that you're part of the countries with the adjudicative pauses? If you're from one of the countries with the adjudicative holds, there's nothing anyone can do. You're just within those same adjudicative hold as those 39 countries until they start lifting those. But again, as I mentioned earlier, you're in what we consider a normal timeline right now for VAWA cases. Do you advise one to travel with advanced parole gotten via VAWA at the moment? I've never overstayed, and I also have a pending EB2. Without knowing your case, honestly, I can't say. Like with travel, I really need to know your personal history. Again, if you guys want a personal consultation with me, you comment yes. I'll have a link sent over to ask more questions to understand, your own particular case. But there're just certain questions that I really cannot answer, because I don't want to tell you to do something without knowing everything. And I don't want you to necessarily share your personal information on the World Wide Web. So I know some of you are commenting yes on Facebook. And unfortunately, the yes only works on Instagram right now, where we can be able to send you a link after the live to write whatever the issue is. So if you want, you can comment after my live is done. You can go on my Instagram and comment yes on this live. But next week, you'll be able to do that on YouTube and Facebook as well. But till then, you can always go on my Instagram live and comment yes, and I will look at yours if I'm not able to answer it right now. Okay. If your asylum petition is approved, there's nothing to do. Your asylum is approved. You're not yet eligible for a green card. It depends on when you got your asylum approved. Is it something that's recent? I'll need more information, but I don't actually handle asylum cases, so I generally don't like talking about asylum stuff. My son is in the US. No, my son is in the U.S. Army. He filed for me. They put me in removal because they were saying I came with the visa, but I overstayed. Do you think I have a chance of fighting it in court? It's next year, June. You 100% have a good chance of fighting it and being successful. So good luck to you. Um, I have a green card, 2-year green card based on abuse, and I got an extension. I've been here for 5 years. Again, you count. I think this is the person that asked the question about when you're eligible for citizenship. You count based on your green card, as I mentioned earlier. So if you have a 2-year green card, you count based on the date on your green card to calculate the 3-year mark to file for citizenship. You want to make sure you have a really solid abuse case, though, before you put in an N400. Can a person in removal status, active deportation case be considered for VAWA? Absolutely. And the person has no landing documents. I'm assuming that you cross the border. You absolutely can. You have potentially 2 options. One, to file VAWA with USCIS if you are eligible for it, or to file VAWA cancellation in court. But with VAWA cancellation in court, you have to have been in the United States for at least 3 years before you entered into removal proceedings. If that's not the case with you, and maybe when you entered the border was when they apprehended you and placed you in removal, if you are eligible for VAWA, you can file for VAWA. Again, sometimes it would really depend on the judge. If you're not detained, it might be a little easier to convince a judge. There's this case pending. Let's see what happens with the case, because they can't otherwise use VAWA cancellation. Again, this is more of a humanity thing, and just having a kind-hearted judge that says, okay, I'll wait and see. For instance, we have a client who has his final individual hearing, which a final individual hearing is basically like your final trial where you basically plead your relief, and they will either decide whether they're approving you or they're ordering you to be deported or whatever. And he filed a VAWA case before he came to us, and that case has been pending. And this is the 4th year. This is going to be the 4th year, but the person is part of one of the banned countries that also has the adjudicative holds here in the U.S. So there was no way that for the person's hearing this month that they would have a decision. So thankfully, that case, the judge ended up pushing out the case till next year to see what happens, to give the person time. So again, with removal cases, a lot of things there's a variable to it. It's all depending on who the judge is and the judge's empathy or compassion, or outside of applying the law, because of course they have to apply the law, but there's certain things that they have the capacity to do and not do. You could also have a judge who says, like, for instance, if you're in detention, where a lot of what the judges are doing now with people in detention who have been detained is, if they deny you bond, they will be denying based on them saying that you're a flight risk. And even if you have a case pending, they will say, well, that's speculative. We don't know if they're going to be approved or not. And so they usually want you to plead something else in court. So for someone like you who may not have the 3 years, if you find yourself in that situation, that's more challenging. So it just really depends. Again, I have to jump off. Like I said, I can't get to all the questions. You can comment yes now. No, when I save this live, comment yes in the comment, and we'll be able to address as many of the questions as we can. I will be at a USCIS interview tomorrow morning, so I'm not going to be on live tomorrow. I have another one on Thursday and one more on Friday. I have interviews back to back this week, but I will report back next week, Monday, to let you guys know how they all went. I hope you guys have a great week, and I will talk to you all later. Bye.